I am Sorab. Today we will have a look at the case of Adankinare Yanapan versus Bhaskara Krish Taper and 13 others under the Indian Partnership Act 1932. Facts. The members of two joint Hindu families, Narayanapa and Bhaskara, entered into partnership for carrying on business. The members of Narayanapa family filed a suit in 1949 for dissolution of the partnership and the taking of accounts. The members of Bhaskara family raised the defense that the partnership was dissolved way earlier in 1936 and that accounts were then settled between the two families. They relied upon an unregistered document, which showed that the partnership had come to an end. Contentions. Appellant plaintiff. Since the partnership assets included immovable property and the document recorded the relinquishment by the members of Apt's family of their interest in those assets, the document was compulsorily registerable under S. 171C of the Registration Act, 1908. And as it was not registered, it was inadmissible as evidence to prove the dissolution as well as the settlement of accounts. Respondent defendant. 1. There is no cause of action as the entire claim is infructuous. 2. The suit was time barred. Issue. Whether the interest of a partner in partnership assets comprising of movable as well as immovable property should be treated as movable or immovable property for the purposes of Section 171 of the Registration Act, 1908. Judgment. Supreme Court. The document only records the fact that the partnership had come to an end. It cannot be said to convey any immovable property by a partner to another, expressly or by necessary implication, nor is there any express reference to any immovable property, except the recital of a fact which had taken place earlier. Therefore, the unregistered deed of release by one family of its share in the partnership was admissible in evidence, even though the partnership owned immovable property. Law points. The interest of a partner in partnership assets comprising of movable as well as immovable property should be treated only as movable property. His right during the insistence of the partnership is to get his share of the profits from time to time, as may be agreed upon among the partners, and his right after the dissolution of the partnership, or with his retirement from the partnership, is only to receive the money value of his share in the net partnership assets as on the date of dissolution or retirement, after a deduction of liabilities and prior charges. Property of the firm, under S.14 of the Act, means that the partners are the joint owners and there is no individual ownership over the partner. Whatever at the commencement of the partnership is thrown at the common stock and in the course of time has been owned by the partnership belongs to the firm, unless contrary has been proven. If there is an immovable property, then that property has to be liquidated in the form of money, and then the partner's share has to be settled in accordance to Section 48 of the Partnership Act. That's all for today. Thank you. See you next time.
Created using Powtoon.